Good afternoon. I'm Andrew Lofton from Constitution High School. Do you ever get into arguments with other members of the Supreme Court?
Yes.
And if you do, how do you solve those issues?
Well, what we do after we hear a case, we'll hear a difficult case, and then first, almost all of it's done in writing. I mean, I have these documents called briefs. I'm carrying them around with me now. I have them in my bag. I was reading them in the car coming up. And in each case, different sides file briefs. In the case I just talked about, there were 100 briefs. I couldn't, the schools, different schools filed briefs. The Army filed a brief. We had all kinds. So I read those. Maybe in a typical case, there are 10 or 15, 20. Then we'll have an oral argument, oral procedure. And that is maybe half an hour each side. The lawyers will argue. We'll ask questions. Then within a day or two, we're in our conference room, the 9 of us. That conference room has a big table. It's probably about the size of the bottom of the auditorium here. And we sit around the table. No one else is in the room. And we discuss the case. When we're discussing the case, the Chief Justice is here. He has a little book. And he says, the issue in this case is ... And here's how I feel about it. Then it goes to Justice Scalia, Justice Kennedy, Justice Thomas, Justice Ginsburg, me, Justice Alito, Justice Sotomayor, Justice Kagan. And we each have a book, and we each write down what the others say. Because if I didn't write down what you said, for example, and I had to write the decision, you might not agree with it. So I write down what you say. Then there's back and forth discussion. I listen to what you say. And I try to see if I have something that's relevant to what you're talking about. It isn't just who has the better argument. It's a question of listening to each other. Now, on the basis of that discussion, we work out, well, how we're probably going to decide the case. The case is then assigned to one of us to write, and we write a little essay. And we circulate it in the court. And I hope that the other judges, or at least 5, will join my opinion. If they don't, they might write a dissent. Eventually, everybody joins an opinion, or writes a dissent and joins that, and that's the end of the case. The majority rules. If there are 5 or more, that's the answer. Now you are an expert. And your real question is, does that discussion make a difference? And the real answer is yes. And when you talk about argument, you're thinking, well, how do we do that argument? Do we shout at each other? I mean, some of these are pretty contentious cases. No, we don't shout at each other. I've been there for 20 years, and I have never heard in that room, never heard one justice raise his voice and shout at another. Just does not happen. I have never heard one judge say something rude or make a joke even about another. Doesn't happen. It's civil, and it's polite, professional, even though we might strongly disagree. So I've learned over time that if you have a friend and you're disagreeing about something and you're in a big argument, what works best is stay calm. Stay calm. Listen to what he's saying. Try to deal with what he's saying, not with what you're saying. What do you think he's thinking about? He's thinking about what he's saying. He's not thinking about what you're saying. Otherwise, he'd agree with you, wouldn't he? And so listen to him and stay calm. If you do not stay calm, he's going to think, my God, that guy's really emotional. He must be wrong. You say, isn't that how people think?
Yes.
Yeah. So therefore, what I've learned is the 2 rules in there, in that conference room. Don't speak twice till everybody has spoken once. That is a great rule for whatever group you're involved in, because everybody thinks they've been treated fairly. And then stay calm and listen and respond to what the other person has said. You would be surprised. You would be surprised at how often you can work things out. And if you do, you don't even have to get into court in the first place.